Today's speaker is none other than Bill Richter. He's one of the key people in our community that has helped so many startups and larger companies in in dealing with the mazes of legal work out there. And he is, I know I've used him quite a bit in the past. He was part of the Santa Cruz Works board, so he comes with very high recommendations from us. And at this point, we're going to ask Bill to activate his video and audio. And there he is. Hi, Bill.
Greetings. Hi.
We got you
Welcome,
there.
everybody.
I'm going to disappear. So we're passing it over to you, Bill.
Great. Thanks, everybody. And Doug, thank you. Melina, thank you. I do want to encourage everyone to become a member. And Doug and Melina, send me my renewal sponsor invoice afterwards so I can take care of that. And I encourage everyone to join at whatever level you can. I want to start out by saying just a couple of ground rules. My presentation is not legal advice, so this is informational. Don't rely on what I say as applicable to your particular circumstances and situations. Also, if there is an opportunity for questions and answers at the end, please do not share confidential information. I am going there's a lot of material here. Most likely, you are not familiar with this. I have a lot that I would like to try to get through. So I'm going to try to go through this fast and take questions only at the end. And with that, let's get started. So this is my mission statement. You'll be able to get a copy of the slides later, or I can send them to you. But basically, I've been in practice as a solo lawyer in Santa Cruz on Pacific Avenue since 2002. And I just really enjoy working with individuals, entrepreneurs, investors, inventors, starting sometimes well before they form their company and going as far into the future as possible. And I'm grateful to the Santa Cruz community for support of my practice. Next, please. Corporate Transparency Act. If we had some musical effects, this would be the time, or to quote from Shakespeare, if you have tears, prepare to shed them now. These are the topics to be covered, and I'm just going to launch right into it. Melina, next, please. So the Corporate Transparency Act and its various regulations mandate the creation of a national database of individuals who are deemed to be beneficial owners of reporting companies and the individuals who create them, so lawyers, paralegals. The information that's going to be collected under this law is referred to as beneficial ownership information, BOI. You could also think boy, oh boy, by the time we're done. The basic idea behind this law, which has been a long time in coming, is to help law enforcement writ large prevent and combat money laundering, sanctions evasion, terrorist financing, corruption, tax fraud, drug trafficking, organized crime, funding of domestic violent extremism, illegal weapons procurement, and you name it. And also to bring the US into line with numerous other countries that have also established national databases collecting this kind of information. If you were thinking, gee, there's an organization that has, or an individual that has 600 LLCs and no one knows who owns them, the government will eventually find out who owns all those LLCs. This is to protect against illicit use of shell companies. Now let's go to the next slide. Basic definitions. Okay, so there are really 5 definitions that give the law its teeth. reporting company, beneficial owner, substantial control, ownership interest, company applicant. You might think that these definitions are going to be relatively clear and clean. The government agencies that have brought you this legislation drafted this effectively through law enforcement and not so much the business community. So definitions that you might be familiar with from the securities laws or other laws may not actually apply. So, and in a lot of cases, in order to have sort of an interim effect of this law, definitions are intentionally not very definite. Let's go forward. So reporting company. So basically, every entity, no matter when it was formed, that was formed by the filing of a document with a Secretary of State, is a reporting company. That's single member LLCs, the corporations, basically everything except for some categories of exemptions, which we'll get to in a moment. So that you would not need to do it, I read through the nearly 100 pages of the Federal Register that describe everything about this, or everything that has been produced. There's a very interesting chart that basically says that FinCEN, which is the agency of the Department of Treasury that's responsible for this, is estimating that in 2024, there will be 32.5 million reports filed. And they estimate that that will take the 32 million businesses in this country 118 million and a half hours, and will cost in the aggregate $21.6 billion. And those are using very low hourly wages and probably vastly underestimating the amount of time it's going to take. They estimate that it would take, if you have a simple structure in your reporting company, which might be, one founder and a lawyer, or two founders maybe it'll take you 90 minutes. If you've got a more complicated structure, which of course everybody will have, it's going to take about 650 minutes. That's what the government is estimating it's going to take for everybody, whether you're a plumbing business or a tech company, to deal with this. The total that they expect this to cost with all the applications and everything that gets done is going to be about $22 billion. And they're expecting, in addition to the initial reports, updated reports, and a total in year one of almost 40 million reports. This is by a government agency that typically gets about 13,000 inquiries a year. And will not have the resources to answer questions. Just imagine if 10% of the reporting companies have a question, that's 3 million calls to a government agency that is vastly understaffed. Next page. So there are exemptions. You can look at this, you can try to find yourselves, but I guarantee you very few of you will find yourselves in this. The exemptions that are, because again, any entity that's created by a filing with the Secretary of State is going to be covered, except for these. So a couple of things are clearly exempt, like general partnerships, because they're not created through a filing. Public companies are not going to be covered by this, but let me talk briefly about a couple of the exemptions, just so you can get a sense. So subsidiary. So if you have a subsidiary, as long as the subsidiary is wholly owned by an exempt entity, like a quote large operating company, which we'll talk about, that's fine. There'd be an exemption. Inactive entities. So you might think, gee, I created these corporations and LLCs that I haven't been using. I'm glad to see I'm not going to have to file. Let's talk about that for a moment. The regulations define inactive entity as an entity that was in existence on or before January 1, 2020. That's the effective date of parts of this law. It can't be engaged in active business. It can't be owned directly or indirectly, wholly or partially by a foreigner. It can't have had any change of ownership over the last 12 months. It can't have sent or received funds in an amount greater than $1,000 in any 12-month preceding period, and it doesn't hold any type or kind of assets, including ownership interests in any other entity. So for a lot of people, and I know a lot of my clients who have these companies just lying around, don't assume that you're going to be exempt by virtue of having just sort of ignored it for a while. Venture funds will have their own issues. Carried interest are going to make general partners reporting persons most likely. But let's talk about large operating company, because that might be a place where companies can find an exemption. To be a large operating company, you have to meet all of the following conditions. You have to have at least 21 or more full-time employees in the US. And that's not averaged over time. It's got to literally be 21. Your previous year's federal tax information return needs to demonstrate that you had gross receipts or sales of at least $5 million. That means in your first year, you can't possibly, even if you had 21 employees, you can't possibly be a large operating company exempt from these requirements because you could not have filed a tax return for a year before you existed. You also need to have an operating presence at a physical office in the US. And for companies that have now gone fully remote, this will be complicated. So let's go to the next page. Okay, so the next definition is beneficial owner. So a beneficial owner is anyone, unless you're excluded, who directly or indirectly exercises substantial control over one of those reporting companies, or owns or controls at least 25% of the ownership of one of those reporting companies. And there are some exceptions. Individuals who have control solely by virtue of being employees, as long as they're not senior officers, would be exempt. Children are exempt. Folks who hold future interests in reporting companies through inheritance will be exempt under most circumstances. Creditors will be exempt from the definition of beneficial owner. But this is going to be complicated because the kind of information that's going to need to be reported could create issues, particularly for students and particularly for folks who might have visa and immigration status issues. The kinds of information that are going to need to be filed could compromise or disclose their immigration status. Keep in mind that this database is going to be available to law enforcement, which is every single agency of law enforcement that you can think of. Beneficial ownership, the whole idea behind this is to get up or down the chain through however many different levels and layers and LLCs and corporations to natural persons, to individuals. So, having an entity that has, Cayman Islands and this, that, and the other thing, this is going to go all the way through and find the individuals at the end of these food chains. Next slide, please. So substantial control. So reporting companies are going to be required to identify all individuals who directly or indirectly exercise substantial control. There's no limit to how many people this could be in a given company. The different categories are senior officers, So president, CEO, CFO, general counsel, chief operating officer, and there are catch-alls everywhere. Anyone else, any other officer who performs a similar function regardless of title. Any individual with the ability to appoint or remove a senior officer or a majority of the board exercises substantial control. So in my case, if I'm the incorporator, as part of my job as incorporator, I appoint the initial board, I'm going to fall into this category. Interestingly, members of a board of directors do not necessarily fall into the definition of substantial control, but they could. And even independent directors could. Important decision makers also exercise substantial control. That's any individual who directs, determines, or has substantial influence over important decisions made by the reporting company, including decisions relating to the business, like nature, scope, and attributes, selection or termination of business lines or ventures or geographic focus, the entry into, termination, or fulfillment or non-fulfillment of significant contracts, that's substantial control, or over finance, like sale, lease, mortgage, transfer of principal assets, major expenditures or investments, issuances of equity, incurrence of significant debt, approval of an operating budget, puts you into substantial control territory. If you have control over whether the company merges or amendments to governance documents, including articles and bylaws and significant policies and procedures, you're going to be within the web of substantial control. And if that isn't enough, there's a catch-all under the regs. Any other form of substantial control exercised over the reporting company. And the idea here is to prevent people from coming up with new schemes, and it's going to be complicated. Rights associated with financings could result in substantial control. Ability to appoint, board members, or under charter protective provisions, company can't do X without, the majority of the preferred agreeing. Lots of things are going to be caught up in this, and you're going to have to trace this all the way through to the last individual. Next page, please. Ownership interests. This, again, you would think should be easy. Trust me, it's not. Reporting companies are required to identify all individuals, so again, going all the way through your chain, who own or control, directly or indirectly, at least 25% of the ownership interests of the company. So if you're like me, when I first thought about this, I thought, oh, great, well, there can't be more than 4, because 4 times 25 is 100. That's totally wrong. We'll come to that. So what are ownership interests? Stock, equity, voting rights, if you're an LLC, capital or profits interests, convertible interest, promissory notes, and safes. This is going to be really complicated. Options, warrants, puts and call, rights to buy or sell equity, and the catch-all, any other instrument, contract, arrangement, understanding, relationship, or mechanism used to establish ownership. This is intended to, get to the situation where, people don't have their fingerprints on anything, but they still somehow benefit from owning something. It is going to be very complicated to calculate this because in the case of convertible notes, the regulations say, and I'll just quote, even if the instrument is not immediately convertible, the potential conversion of the instrument at a later time provides significant opportunities for exerting influence and maintaining an economic interest tantamount to ownership. Excluding these interests, like convertible notes, would create significant room for potential evasion of reporting requirements. In the case of safes, simple agreement for future equity, the regulations say, it may be difficult to calculate how much equity will be received when the relevant condition occurs. If the condition does not occur, the investor may receive no equity at all. Although FinCEN, the government agency, recognizes that such structures may complicate the calculation of percentage of ownership interest, investors and companies who establish such structures do so in the expectation they will receive a certain level of capital and profits interest. it's going to be very complicated to calculate this. Once you know what the ownership interest is, then how do you calculate 25%? And this is going to be complicated because of safes and convertible notes and options. You would calculate this by taking the total combined voting power of all classes of ownership interest that you have as a total percentage of the outstanding voting power of all classes of ownership interests entitled to vote. So you assume that all of your options, vested or not, are exercised, but that nobody else's are. So yours is the only one that appears in the numerator and denominator. The fact that the company has an option plan and options to 20 other people, you don't take that into account in your calculation. So you can see very quickly how you can end up with more than 4 beneficial owners. If you can't, and the other way to calculate is the total combined value of the ownership interests as a percentage of the total outstanding value of all classes of ownership interests. Who knows how to do that? So basically what they say is, if you can't calculate either of these, you then you calculate 25% of any class of equity you own. So if you're a founder, you might, if there's 2 founders, you might have 50% each of the common stock, which might represent only 1/3 of the companies. But that, that 50% may be enough to do it because we're just going to look at the common stock. It's going to be complicated. Next please. Company applicants. So in addition to companies, company applicants are going to have to make filings. So who is a company applicant? And you would think this is easy. Any individual who files the application to form a U.S. entity or to register a foreign entity to do business in the U.S. Fortunately, they only expect there to be 2 per reporting company. So to my mind, it's the corporate lawyer, let's say it's me, and you're the founder, you're the prospective founder saying, hey, let's go file in Delaware. The regs say it's the person most responsible for causing the filing to be made. So folks are beginning to wonder, so, okay, lawyer, paralegal in a law firm, the filing service that you use in California or Delaware, that individual who runs it to the counter. What about the courier? This is going to be complicated and no one, again, the definitions are not totally helpful. Now, companies remember I said that reporting companies are all companies from the beginning of time that are not exempt or, have been dissolved. Companies in existence as of the end of this year don't need to go back and figure out who their incorporators were and who did all this because, you're a 25-year-old company, you're never going to find that person to get the information that's needed to fill out this report. Companies that get formed next year, the company applicant will have to file. And fortunately, once you've filed the information for your company applicant, you're not going to need to update it. Updating is, we'll talk about that, that's its own can of worms. Let's keep going. So who has to report? Everybody, all reporting companies, but who's responsible in the organization to do it? So the regs say senior officers are, as well as anybody else who willfully directs a reporting company not to report or willingly fails to report while in substantial control of a reporting company. This is putting the obligation to file squarely on a number of people. Now, in an organization. Fortunately, individuals can make their own reports and they can provide this information about themselves to FinCEN and get a FinCEN identifier, which is a number, and then you just give that number to the company. But basically, the who has to report, it's all reporting companies, and within those companies, there's personal liability for senior officers and anybody who basically says, hey, it's not so important. Next. What gets reported? Okay, again, this sounds like it could be easy, but let's talk about it. So for reporting companies, you have to report the full legal name. That's actually knowable. Any trade name or DBA, and you have to report all of them. So you have to start thinking, what are our trade names and DBAs? You need to provide a complete current US address of the principal place of business in the US, or if overseas, then overseas. The jurisdiction of formation, that's pretty easy. Taxpayer ID number, the TIN, including an employer ID number or the EIN. Some companies may need a lot of time to get these, depending on the immigration or citizenship status of their founders. But this is the kind of information that will need to be reported by the company. Plus, next slide, please. That other information relates to the entity. Now we get into the information that the company must report about its beneficial owners. And this is going to be tricky because not all of your owners, beneficial owners, may want to give you this information. But you're going to need to provide in the filing the full legal name of each beneficial owner. That's the person at the end of the food chain. Their date of birth, their complete current address, a unique identifying number, and the jurisdiction that it was issued in, and an image of either a US passport, a state driver's license, or some other government ID. Different people, if you don't have a driver's license and you have to provide a passport, that's providing more information that's necessary. But again, if an individual has gone out and gotten this FinCEN identifier number, then the information that gets reported is just that number, and then the government is presumed to have all the relevant information. Next, how to report. So no reports can be filed until 1/1/24. There's going to be a secure filing system known as BOSS. It's still under development. We'll be getting instructions and other guidance at this website. You can go and you can sign up to get updates. When you do apply, you're going to need to go in through login.gov. That's something that you can sign up for now. You can apply starting on January 1, and I'm going to do this shortly after. You can apply for a FinCEN identifier yourself, so you don't need to give your companies copies of your driver's license and all this information, because who knows what's going to be hacked inside companies or even from the government, in that matter. When you make this report, you would think, again, maybe this should be easy. There will be a website from FinCEN, but the understanding from people who have studied this is that you may not be able to save the form. So when you do it, you would need to complete the entire thing, which means having all the information ready at once. It may be that the recommendation will be to do this by using a PDF so you can save and upload it and have a record of it, because if and when your driver's license changes or you move to a new address and you need to update your report within 30 days, you're going to need to include all the original information, and you might not get a copy when you have filed this online. So one of the other things to note is that there will probably be a host of third-party vendors that are going to spring up to do this. That's going to require a lot of diligence about these organizations before anyone would choose to use them, and it may actually not be the best thing to do. Next slide, please. When to report. So when I initially talked to Doug and Melina about this, companies that were going to be created in uh, after January 1, we're only going to have 30 days to do this. Now it's 90. So there's a little less urgency as to when I originally proposed this to Doug and Melina. But companies created or registered to do business before January 1 of 2024. Good news is you've got until January 1, 2025 to take care of this. For companies that are created or registered to do business in the US after January 1, 2024 and below and before January 1, 2025, you're going to have 90 days. But you're going to have to report updates in the event anybody's beneficial ownership information changes. You get 30 calendar days. You're going to need to have a way to make sure you get that information. Next, please. Penalties. Okay, so there's personal liability on the part of senior officers and people who control the company. If you don't do this, there's a civil fine of up to 10K, accruing $500 a day a report is outstanding, up to 2 years in prison. If there's unauthorized disclosure or use of this information that your company has collected, there will be penalties. When you file this, there's no, to the best of my knowledge, this information is accurate and complete. There's no knowledge qualifier or we filled this out in good faith. No, this is an absolute statement. Someone in your company is going to need to sign this, and they're going to need to know that that information is correct, and here are the penalties. From the agency itself, FinCEN recognizes that much of the information reported to be required about beneficial owners and applicants will be provided to reporting companies by the other individuals. However, the structure of the Act reflects a deliberate choice to place the responsibility for reporting this information on the reporting company itself. The fundamental premise of the Corporate Transparency Act is that the reporting company is responsible for identifying and reporting its beneficial owners and applicants. It is appropriate to expect that reporting companies will take care to verify the information they receive from their beneficial owners and applicants before they report it to FinCEN. The government takes the position that if there weren't a requirement for individuals to have personal liability, illicit actors could find ways to get around all of this. So someone is being tagged with this being correct, and that someone is going to be the people who control the entity, and probably others. Next. How to get ready. So for companies that have this full year to think about, to get this done, here's a list of some things that occur to me that you can be using this year to do. You can begin to figure out, is our entity exempt or do we have to file? You can begin to figure out who are our beneficial owners. Again, if there are venture funds and partnerships and God knows what, you're going to need to sort of go through this taxonomy and figure it out. You're going to need to start telling these folks that they're going to need to give you this information, including, copy of their driver's license or passport. You're going to hear that some people are, hell no, I'm not going to do that. Well, you're getting into a situation where they either do that or your company is in violation of federal law, and we know what the consequences are. You are going to need to think about what you can put in your investment agreements, founder documents, stock purchase agreement, options agreements, trusts, to make sure that you can collect the information that you're going to need for your company to file this. You're going to need to review confidentiality clauses in your agreements because there may be restrictions that the company has agreed to not to disclose information relating to certain investors. That's going to need to be sorted out. You're going to need to figure out who in the company is actually going to be responsible for doing this and monitoring this and collecting the information and filling out the form and signing. You can use this time to figure out how are we going to protect this information from hacking? How are we going to implement and maintain reasonable technical, administrative, physical security measures to protect this information from unauthorized access, use, or disclosure, for which there are penalties? You're going to need to figure out, are there issues with GDPR if you've got European investors? You're going to want to talk about this with your board and investors. You're going to want to review revocable and irrevocable trust that may control 25% of a reporting company to figure out if the beneficiaries and trustees need to report information. You're going to want to figure out, can we require indemnification from folks who refuse to give us this information for purposes of monetary penalties? You're going to want to figure out, again, how are we going to store this information, and what happens if we should be hacked or lose control of the information. And one of the answers may be to push all of the obligations to provide this information to those individuals who are the beneficial owners, and have them apply directly to the government and make the filing of their information directly to the government to get their FinCEN identifier. There's a lot to think about. And I think in documentation that I'm working on now, I'm beginning to put in covenants for option holders and investors and others to provide this information. Whether people actually see that, because it's not really called out, I don't know, but I'm trying to at least build that in, and you may want to do that as well. Again, because you don't want to end up on December 31st of next year trying to figure this out and having to make a filing and being wrong. Next. Where to get more information. If you go to fincen.gov/BOI, that'll give you links to lots of things. You can sign up to get more information. And special problems next, and then I'm done. So as a corporate and transactional lawyer, when I think about this, I'm thinking, if I'm the investor or I'm the company, I'm going to be expecting due diligence issues. Investors are going to want to know, did the company comply with the CTA? Did it comply with the applicable privacy and data protection that goes along with having collected this? I'm expecting that there will be reps and warranties on compliance in financing and merger documents. I'm expecting that post-closing, there will be filing obligations in a number of different transactions where you might not expect it. In asset deals, mergers, stock acquisitions, exchanges, repurchases and retirement of shares, redemptions, estate distributions, spin-offs, formation and financing of subsidiaries. Each one of these things has the potential to change the calculation of what is 25%, depending on what's issued and outstanding, and depending on what the rights are that are given to shares. And then, if you're in a company that's been sold and you no longer hold equity or have control, you need to get out of this reporting system. Will there be a successor liability if your company is acquired with violations of the CTA? And really, what can you do if people refuse to give you this information? Can you get indemnification? Is there a way to get them to agree that they'll forfeit their interests? Is that enforceable? There's an awful lot that's going to need to be thought about, and so these are the special problems. Okay. What more can I say? If I haven't ruined your day.
I'm terrified. Where can I move to?
Not one of the 30 countries that has similar laws.
Okay. Yeah, I mean, there's a lot there, and thank you for putting it together so thoroughly. We will definitely make provide a recording of all this afterwards and try to boil it down even more, but let's start with questions in the audience, from the audience attendees. If you have some, please raise your hand or put them in chat, one or the other, and we'll get to them right away. Let's see if we have any here. Melina, what are you seeing out there? Anything in Q&A or?
Not right now. No, nothing.
A sole proprietor, what is
Right,
Michael?
so a sole proprietor who's merely registered as a fictitious business is exempt. So I think the answer to that is that a sole proprietorship is not created through the filing of a document with the Secretary of State of a given state. So I think the answer to that is that if you are a sole proprietor, like I am in my law practice, and you have a fictitious business name, the fact that you are not a reporting company is going to spare you from having to make this filing.
Any other questions that we can address right now while you've got?
Government-owned companies. I think the answer to that, and I would have to take a look through this and see specifically what's said. I think the answer to that is that it is exempted, but that's not legal advice. This was a question that I had not really thought about because I figured that was not something that would come up in our community and in our discussion. But I'm glad to look into that. And if you, Sadef, if you want to get in touch with me, I can point you to whatever I can find on that.
What else do we have here? Anything else? If not, we're going to adjourn for the day and for the year. We have a couple more things. We'll just remind everybody, you got a BFF out there. Make sure you nominate them. Just go to the link here to be a Titan, and we'll take additional nominations until end of day tomorrow. And then our board, our illustrious board at Santa Cruz Works, will review and select the final candidates, and we'll let you know. We once again want to thank everybody who's helped us on this journey for everything that you've done. I see that Bill has put into chat his contact information, bill@richterlaw.com. If any of you can't copy that right now, you can reach out to us and we'll connect you with Bill. But again, thank you to all our sponsors. And with that, thank you to all of you for attending.